Good morning. My name is Amanda Rivera. I'm the hearing examiner presiding over today's case. The date is January 15th, 2026, and this is a remand of case DCI2023-00011. The board remanded this case on the limited basis of review of 3 findings of the circuit court. Accordingly, all evidence and testimony today should be directed solely to these 3 points, as that serves as the limits of my permissible review and authority in this case. The first 2 findings both relate to affirmation that the board's decision in this case must be based on competent substantial evidence within the record created solely for this case, without a predetermined outcome. The third finding directs review of FAA advisory circulars for compliance with LDC Section 34-1102. I ask that comments and presentations today be confined to this direction and not veer outside the scope of my limited scope of review on remand. To that end, because this is a quasi-judicial hearing, all evidence and testimony must be taken under oath. So if you intend to speak, if you could please raise your hand. Do you swear or affirm the testimony you will provide is the truth?
Yes, I do.
Thank you. Just for reference, the record from the prior case has been incorporated and is included in the record of what we will be proceeding today. And if we do start to veer outside the scope of my review, I will gently remind you to please stay back into the course of what we are limited to talk about today. It is an incredibly narrow scope of review, so while we are welcoming comments, again, they've got to be focused on what we are here to talk about. I did receive both parties' 48-hour memos, and the staff exhibit 6 was labeled as the affidavit of publication, so we are permissible to proceed today. So I'm ready with the applicant whenever you're ready.
Madam Hearing Examiner, for the record, Amanda Swindle at the County Attorney's Office. If you wouldn't mind, I'd just like to make a very preliminary statement. I really appreciate your comments about the limited scope.
Sorry, could you come to the podium? Yes, but thank you and welcome. Thank you for coming today. Good morning again.
Thank you so much. Like I said, I appreciate your comments about the limited scope of this hearing. We really do need to stay on the rails here. The only new evidence placed on the record is essentially compliance with the FAA circulars, which include a letter of no objection from the Port Authority. Outside of that, I don't believe that there's any new evidence from the applicant to be presented on this. So outside of any questions about the FAA circulars, we would really appreciate if your recommendation could include a very specific finding, as you outlined, that whatever your recommendation is, it is based solely on evidence on the record from the prior hearing and this hearing. Thank you.
Good morning.
Good morning. My name is Alexis Crespo. I'm Vice President of Planning with RVI Planning and Landscape Architecture. It's a pleasure to be here this morning. I'm here on behalf of the applicant. We have submitted a 48-hour letter to the hearing examiner's office noting that we are in full agreement with the staff report, including the limited revisions outlined therein on the December 22nd, 2005 copy. I am a certified planner with the American Institute of Certified Planners. My resume is on file with Lee County and been deemed an expert in land use planning, the Lee Plan, and Land Development Code, and would respectfully request that my testimony be treated as such today. And as you noted, there is a lengthy record attached to this application. The record attached to this application demonstrates the client has previously provided and met the burden of competent substantial evidence and includes that the CFPD zoning application and supportive materials submitted to Lee County by the applicant, the original and revised staff reports, and the presentation and expert testimony provided at the hearing examiner public hearing on October 19th, 2023. So we're dealing with the breadth of those materials. You also have an updated letter from the Lee County Port Authority issuing a letter of no objection to the project as indicated in the staff report, which Laura Herrera will touch on in her testimony. Due to this evidence already in the record, I have no further testimony or evidence to present or to supplement the existing record. I will rely on that extensive data and analysis and testimony provided to date. And it does remain in my expert opinion that the CFPD zoning request is consistent with the Lee Plan, consistent with the Land Development Code, and meets or exceeds all criteria for approval. And I'm happy to answer any questions you may have.
Specifically with respect to the FAA circular, have you done zoning projects proximate to the airport in Lee County previously?
Yes.
And has that particular issue been addressed at the zoning stage, or at what point, I guess, in the process is that typically raised?
What I testified to in the previous hearing and what I've dealt with as the land use planner, not the environmental consultant, is when you have projects within 10,000 feet of the runway and limiting lake design, littoral plantings to ensure consistency and compatibility with wildlife interfacing with the airport, and Ms. Herrera will deal with that in more detail.
Okay, so I'll address my questions. Thank you.
Thank you.
Good morning.
Good morning. I am Laura Herrero, for the record, here on behalf of the applicant. I am an ecologist with Johnson Engineering. I have been accepted in this forum before as an expert on environmental planning. My resume is on file. One thing I do want to point out, my resume does show that I am an FAA qualified airport wildlife biologist, so I do just want to bring that up for today. It is important to note that the FAA advisory circulars are guidance documents intended for the aviation industry. As Alexis mentioned, the Lee County Port Authority has provided a review of the project and provided a letter of no objection based upon very thorough review of all of the advisory circulars. Staff has done a very thorough review of those circulars, which is included in their staff report, so we are going to rely on that review right now for that testimony, but I can answer any questions that you may have.
Just one as a factual point, I think the testimony just was that they apply within 10,000 feet of the airport. My understanding from the staff report is that this project sits outside of the 10,000 foot radius.
So this project does sit outside the 10,000 foot, what we call separation buffer from the Southwest Florida International Airport air operations area. It's about, I think it's about 18,000 feet, I believe, from the existing runways, about 13,000 feet from the future parallel runways. So it is outside the 10,000 foot separation buffer, yes.
So they would not be applicable generally to a request of this nature?
So as the staff report will get into, there are some other instances where they look at things. When it comes to the specific land use that we're looking at, there's a 10,000 foot separation buffer that they look at. They will also reference a 5-mile buffer for projects that may have the ability to potentially attract what we call, wildlife to the area. In that instance, when they look at that, they want to say, is it going to be creating a hazardous wildlife attractant? And when they look at the circular, they specifically define hazardous wildlife attractants to be within proximity to the air operations area that I had mentioned. Aircraft arrival and departure, that's going to be using the airport, and also runway protection zones. So although the project is within 5 miles of the airport, it is outside of the airport AOA, outside the 10,000 foot separation distance. Lee County Port Authority has, provided the arrival and departure paths. The project is outside of aircraft arrival and departure paths, and it is outside the runway protection zones.
So your expert testimony would be that the request remains compliant with LDC section 34-1102?
Yes, ma'am.
Okay, thank you.
Any other questions?
That was all for now. Thank you.
Thank you.
All right, was that the entirety of the applicant's presentation?
Yes.
Okay, thank you. Then I'm ready for staff.
Good morning. For the record, my name is Anthony Rodriguez. I am the zoning section manager with the Lee County Department of Community Development, and I'm here to provide a staff presentation on the remand hearing this morning. I do have copies of my PowerPoint for the applicant, for your office, as well as for our court reporter, and I'd like to submit those into the record.
Thank you. So that will be staff exhibit 7. Thank you.
So it's been a little while since I've been in this forum. I have been previously qualified as an expert witness and an expert in Lee County Land Development Code, the Lee Plan, and just general planning discipline, and I'm seeking to be qualified as such today.
Yes, thank you.
Thank you. So to summarize the request remains unchanged as part of our remand hearing this morning. This is a request to rezone 112.21 acres from agricultural, AG2, to community facilities planned development to allow the development of a wastewater treatment plant, which is classified as an essential service facility group 2 by the Land Development Code. And that development program is comprised of 25,000 square feet of office, maintenance, and administration buildings, as well as the infrastructure necessary for the treatment of up to 10 million gallons of wastewater per day. Staff continues to recommend approval of the request, subject to the staff recommended conditions of approval and deviations that are attached to the staff report published October 4th, 2023, as modified by the hearing examiner recommendation issued in December of 2023 and incorporated into Resolution Z23035, adopted by the Board of County Commissioners on January 17th, 2024. I apologize for the language being cut off. I did my best. This slide outlines a summary of proceedings. How did we get to this point? The application for this particular case was filed in March of 23. It went through the sufficiency review process and was heard before you, Madam Hearing Examiner, on October 19th, 2023. You issued a recommendation to the board of approval subject to conditions and deviations in December of 23, and the board voted to approve that rezoning in January of 2024. Subsequent to that, on February 16, 2024, there was a petition for writ of certiorari filed with the 20th Circuit Court. In the interim, while the legal proceedings were playing out, an application for local development order approval was submitted in September of 24, and that application was approved in May of 25. There were oral arguments heard before Judge Schenko with the 20th Circuit Court in August of 25, and the court entered in a motion granting petition for writ of certiorari in October of 24. So in response to that, the board remanded the case to your office in December, and here we are in January. I don't want to belabor the point. You've gone over what the scope of this remand hearing is. So I'm going to present some expert testimony relative to the basis for approval and the previous board action, which I'm going to address kind of in tandem. And then I'm going to focus the bulk of my presentation on compliance with FAA advisory circular requirements that were cited in the judge's order and are codified in the LDC. So the basis for approval and the previous board action, as many of the people in the room are familiar with, the criteria for approval of rezonings is set forth in Section 34-145 of the LDC, and it requires the hearing examiner to make a finding that the request meets these criteria listed on the screen. I don't want to go into them in any particular detail because they've already kind of been hashed out. In addition, for plan development rezonings, the hearing examiner is required to make a couple of additional findings relative to the appropriateness of uses, conditions of approval, and their nexus with impacts to public interest, as well as the burden of proof for any particular deviations that are requested as part of a plan development rezoning request. As you alluded to before, the basis for approval is based on the evidence of the rezoning request compliance with criteria for approval that's spread throughout the case record, both in the staff report, in the oral evidence and testimony that was heard during the initial hearing, as well as in your recommendation as referenced in the Board of County Commissioners rezoning approval in Resolution Z23035. In addition, LDC Section 3483 does require the board to base its approval or decision on competent and substantial evidence presented in the record. And the staff's review of the record on remand does confirm that the applicant has demonstrated that the request complies with the LDC established review criteria for approval. Staff does recommend, staff's recommendation of approval in prior proceedings, again, is based solely on the evidence and testimony previously presented in this forum, as well as before the Board of County Commissioners. I'm going to move on now to the bulk of the presentation, which is related to the FAA advisory circulars. This is essentially a summarization of what has been prepared in the remand staff report that was published back in December of 2025. So the first one I'm going to talk about is Advisory Circular 150/5233C. This is codified in LDC Section 341102 by reference, and it establishes advisory guidance for hazardous wildlife attractants on or near airports. It also, the advisory guidance document recommends that a wastewater treatment facility be located at least 10,000 feet from an airport's air operations area. And as Ms. Herrero referenced before, the advisory document also advises a distance of 5 miles between the closest point of the airport's air operations area and the hazardous wildlife attractant, if the attractant could cause hazardous wildlife movement into or across an approach or a departure zone. Typically, these types of requests, as recommended by the FAA, are reviewed by qualified airport wildlife biologists. Part of that review, the scope of that review, is meant to identify measures that can avoid or reduce a facility's potential impact to hazardous wildlife. And if none can be incorporated, then the airport operator should document their opposition in the letter to the local jurisdiction. So you've already heard a little bit about separation. This is attachment G of the staff report, and it's meant to illustrate distances between the subject property at its closest point and the airport operations area. And it's a little messy on the screen, but I think it's clearer in the staff report. But the really important thing to note is that the property is located outside of the 10,000-foot air operations area, as we've already discussed. The review and the scope of the review on the remand addresses not only the existing runway, but also the planned future runway, which is actually located to the southeast of the existing runway, and so by virtue of that location is a little bit closer to the subject property than the existing runway. Nevertheless, taking that into account, the closest point of the subject property to the future runway is 13,400 square feet, and that's to the western end of the future runway, which is kind of right about here. And those distances are noted in this figure. In addition, the LCPA, the Lee County Port Authority, who is the entity responsible for operating RSW, did issue a formal letter of no objection, which is attached to the staff report for the remand hearing as attachment F.
It's just a very basic question. 341102 references FAA Advisory Circular 150-5313A and 150/5233B. So is 33C, was that a renumbering?
So what happened, and there's a footnote in the staff report that kind of addresses, I don't want to call it legislative history because it's advisory documents, but kind of tells you the story of how this document gets updated over time.
I just want to confirm for the record that this is the governing document this county is responsible for looking for, and it's because it was incorporated by reference in 34-1102.
And that incorporation is as amended, as may be amended by the FAA. And so this is an amended 33B.
Okay, that's what I wanted for the record.
Good question. The next advisory circular I would like to discuss is FAA Advisory Circular 150-5190/4B. This particular advisory circular is not codified in the LDC, but it was referenced in the judge's order granting the petition for writ. And so what this FAA advisory circular does is it establishes advisory guidance on airport land use compatibility planning. And it establishes 6 core characteristics, which are listed on the screen, and I'll go into a little bit more detail in a couple of slides, to evaluate when we assess, or when the airport assesses, or whoever the entity responsible is responsible for assessing when it comes to compatibility of a specific land use. So the first one we talk about, or staff is going to talk about this morning, is aviation noise. And I mean, this is kind of pretty self-explanatory. Airports generate noise. That noise is tied to the primary considerations listed on this slide: the volume of takeoffs and landings, the types of aircraft. And noise tends to be like kind of a subjective perception thing. Like everybody kind of feels noise differently. And so the FAA advisory guidance recommends paying attention to that. Also recommends evaluating construction materials, and again, the type of aircraft used in the airport. Obviously, smaller aircraft tend to generate less noise than larger aircraft. So in the context of the subject request, the distance of the subject property from the airport operations area, and I hate to sound like a broken record, I'm going to say it probably about 10 more times, but it is outside the airport operations area. The location of the subject property in relationship to future runways because it's located southeast, it's located out of those approach and departure paths. And when it comes to the use itself that we're talking about this morning, that wastewater treatment plant, in terms of the occupancy, so the amount of people who are going to be required to operate this facility when it's operational, it's really minimal. It's not open to the public. And so when it comes to limiting the types of development in proximity to the airport, this request is consistent with that advisory guidance.
Can I ask, just as a matter of procedure for the county, so I understand this is not codified in the code, so this is outside the scope of what you would be mandated by law to review, but having remembered the first time we heard this case, a lot of these things were discussed and reviewed by staff. So even though you're not under necessarily a legal directive to do so, were the predominant number of these things still looked at the first time?
If you kind of look at what these advisory guidance do, there's a kind of a similarity between the criteria that we evaluate as part of any rezoning request and what these advisory documents are trying to address, right? We're talking about compatibility, we're talking about impacts of a particular use as it relates to surrounding uses. So, I mean, in a roundabout way, I would say yes, we look at all of these things, staff looks at all of these things through that rezoning process. It's not always just in the context of the airport. And so I think that's kind of the differentiation here. The second standard we talk about is effects, or the advisory document talks about, is effects on airspace. Considerations relative to advisory guidance on this front talk about maintaining unobstructed airspace, protecting your navigational facilities, and protecting existing and future airport capacity. And as I alluded to before, staff has evaluated this request not only in the context of the existing runway, but also the future runway. And the distance of this particular project from RSW's existing and proposed runway is more than sufficient to provide for that safety, consistent with this advisory guidance. There's no impact proposed or anticipated for navigational facilities, either physical navigational facilities or instrumentation. And again, the existing and future runway locations are evaluated in the context of the subject request. The next standard established by this advisory document is visual and atmospheric interference. Primary considerations relative to this is preserving an unobstructed view for pilots to allow for safe navigation of aircraft into and out of airports. This guidance is focused on limiting uses that generate atmospheric changes or produce electronic interference, and the advisory document in particular references a couple of separate uses, including open mining or construction activities, large billboards using flashing or changeable messaging, laser light devices, or other source points of smoke or steam. And really what this guidance document is intending to do is to focus on uses that produce those kinds of impacts. So as it relates to the subject request, the end use of the subject property does not present any long-term concerns related to any visual or atmospheric interference, both in terms of the type of use we're talking about, but also the distance. The site's distance from the airport does limit temporary impacts from development, construction-related impacts, which are going to generate some of those dust impacts in the short term, right? And there are no unanticipated operational impacts in the long term from operation of the facility. And the facility's design in terms of the actual infrastructure is primarily closed. I mean, there are some open components, but those are related to storage. The next standard that we're going to talk about is wildlife, and this kind of dovetails with Advisory Circular 150, 5200, 33C. And there's a kind of a relationship between these two documents, but ultimately at the end of the day, this advisory guidance and this standard in particular is required to or recommends mitigating the potential for conflicts between aircraft and wildlife. It acknowledges that certain land uses, including wastewater treatment facilities, can act as wildlife attractants because they provide shelter, food, or water for wildlife. In addition to that, there is a cross-reference to the definition of what a wildlife attractant is. And the really important part to note is the thing that's emphasized, or the clause of the sentence that's emphasized at the end of this sentence. We're looking at wildlife attractants in the context of how they impact landing and departure airspace and airport operations area. And so when we look at the subject request in terms of its propensity or possibility of attracting wildlife, once again, we are outside of the airport operations area. When staff evaluates the subject property, it's well outside of existing and future runway protection zones, and it's outside of the approach and departure zones for aircraft landing and departing from the airport. And then finally, I want to reiterate that the LCPA did review the request and did provide a letter of no objection that is attached to the staff report. Oop, I don't know what I did there. Sorry. The next standard established by this advisory guidance is protection of people and property. And the primary consideration for this standard is making sure that development is outside or limited to, or severely limited within runway protection zones. And so this particular graphic here is from the Land Development Code Appendix C. It's map 2A, and this shows Southwest Florida International Airport's runway protection zones. The subject property is kind of located off of the graphic, but what I wanted to illustrate here is we're looking at the existing future runway protection zones for the existing runway, which are shown in this crosshatch, and then this polka dot pattern is for the future runway. And the advisory guidance from the FAA on this, in this front, recommends that an airport operation agency maintain control of those zones. And so what you see here on this graphic is the airport boundary is shown in this dark gray. And so the majority of the existing and future runway protection zones are located on airport property. And so that's consistent with this advisory guidance. The only portion that's not is a part of the eastern portion here of the of the future runway. And that particular property that runway protection zone encroaches on it's owned by the county, and it's part of Wild Turkey Strand Preserve. So in a roundabout way, there's kind of additional protections because it's preserve area. The final standard discussed in this advisory document for land use compatibility purposes is development density. And the purpose is to limit conflict between airport operations, and development surrounding the airport. And so what this advisory guidance suggests is limiting structures and people in areas close to an airport. The advisory guidance endorses limits on usage intensity, which is a measure of not only the number of structures, but also the number of people per acre surrounding an airport. And it also recommends establishing land use controls that permit low permissible usage densities for areas around an airport. So when we look at the subject request in the context of this standard, again, we are outside of the airport operations area. We're outside of existing and future runway protection zones. We're also outside of airport obstruction notification zones, which ties to height and approach and departure paths for buildings. In addition to that, the usage density of the use at the end of the day, in terms of the number of structures and the number of occupants, is pretty low. And so even though we're outside of that area, there's kind of an additional protection there in terms of the intensity of the use that's proposed by this request. The final advisory circular I want to discuss this morning is FAA Advisory Circular 5300-13B. I believe this is a superseding advisory circular as well. The one that's codified in the LDC in section 341102 is a prior version of this document. And what this does is this establishes standards and guidelines for application at civil airports that are focused on providing acceptable levels of safety, efficiency, and capacity. This advisory document pertains to airport development projects at civil airports. Interestingly enough, this advisory document kind of comes out front in the first couple pages and says, this does not constitute a regulation, it's not mandatory, and it's not legally binding. Nevertheless, staff did review the subject request in the context of this advisory document, and essentially our staff finding is that this advisory document does not apply to the subject request. This is not an airport development project. It's located a significant distance away from the airport. And so in terms of our analysis, staff analysis, the staff has concluded that this request or this particular advisory circular does not apply to the subject request. So, to land it, pardon the pun, the subject request does meet all the criteria for rezoning established in the Land Development Code. The request as conditioned does remain compatible with existing and planned uses, which include the airport. The staff had undertook a significant analysis of how this site will impact surrounding uses, which include the airport. And the proposed use of the property remains appropriate in the context of the LDC established review criteria. And staff has concluded that the request does comply with the applicable FAA advisory circulars to the extent that they are applicable. That concludes my presentation. It's kind of poignant we're here this morning because this is the 17th anniversary of the Miracle on the Hudson, which I heard this morning on the way in. So. Sully Sullenberger, there you go. Happy to answer any questions you have.
I asked as I went through, did applicant have any questions of the staff?
We do not.
Okay, thank you. Okay, so I'm going to open up public comment, and I will take the cards in the order that I have them. Again, I would just remind everybody, I don't like to interrupt folks when they're speaking, but if we start to go outside the bounds of what we can discuss, I will remind you to get back on course, because we are, again, under very limited guidance today. Truthfully, the first two criteria, as you have heard, are not directed towards me. They are not things that I can review, so we're really focused on the third component, which is the FAA circulars. So the first card that I have is from Marcia Ellis.
Thank you. So Anthony, here's the supporting documents.
Oh, thank you.
You're welcome. And I did provide the PowerPoint by Alexis. I'm not sure if you saw it this morning.
I did, thank you.
Okay. And to the transcriptionist. And Madam Examiner, I do have a hard copy.
Yes, please, thank you.
May I?
Yes, thank you. That would be, thank you. I had,
Yes, ma'am. It's Ellis Thomas
Composite.
Spawn.
so this will be separate. Okay, this will be exhibit, is there one?
Yes, it's separate than the supporting materials that are provided in a hard copy for Anthony.
Okay.
And if you'll just bear with me, I like to get my,
And just to clarify, this all relates to the FAA circular issue.
yes, ma'am.
I'm ready.
Good morning. My name is Marcia Ellis, for the record. I am a petitioner on this case which quashed the rezoning. And I live at 17850 DeVore Lane, 33913. I want to adopt and bring forward the previous record for this case in consideration. I'm also going to say that I've appeared here before, and I have an interest in supporting public comment on and supporting citizen participation at all levels of government, especially in local government, and also bringing forward and helping folks get contemporaneous science-informed information into their contribution for how our community develops. I have worked in education. I work in advocacy now, supporting the community in that role. And I ask that you just give me a bit of discretion. I think that I have some skills and some knowledge and some expertise from that lived experience and from my education that I hope you find valuable, as the previous hearing examiners have acknowledged.
And again, not to interrupt you, it's no disrespect. So if
Yes,
you
ma'am.
interrupt and if I do ask you to get back on course, it's simply because I do not have the jurisdiction or the authority to consider things, and I don't want you to direct your efforts to something that is not fruitful, because I cannot consider things outside the scope of what the board has specifically remanded this item on. So the FAA circulars, again, is really the only thing that I can touch.
So I'm just going to go and just start just as a preliminary, also speak to some issues with the notice, the previous noticing that has come across, and also for both the last hearing in front of the board, as well as the noticing that has been sent to the surrounding property owners throughout the community, some of whom are appearing for the first time today. So I have an issue with that. Also, I'm just going to broadly speak about omission, that leaving key information out, constraining the record is wholly inappropriate. Especially when we're talking about, let's reframe this, we're talking about site suitability in relation to airport compatibility.
And again, I don't want to interrupt you, but I need you to understand, I don't have the jurisdiction to give you any relief on those matters. So if you were correct, there may be legal recourse for those things, but it would be outside the scope of this hearing. I can't offer you any relief on noticing issues or on site selection.
Correct.
The site is selected prior to the time it comes to this venue. Once it's here, I can't relitigate and decide whether it was the appropriate site or not. That's not
I understand that, and your advisory opinion on this is well valued, as is the advisory opinion. I'm just pointing out that when we have omissions and we have a constrained written record, because I'm primarily concerned with the written record, because that should be informed with the issues so that you have what you need to make the decision makers have what they need, and that the written record is also preserved for review.
And I appreciate that. Again, though, I am not at liberty today to take all of this into account again. The board has.
Sure.
I get my authority from the board and from the Land Development Code. And in this context, it was limited on those three issues.
I get that.
Okay, so
And
these
so-
things don't, this is outside the scope though, so I'm not sure that.
I've not even started, so.
I understand, but even this photo, and you're talking on the side about defiance and broken promises, those aren't things that I can assist with. So I just want to be sure that we're.
Sure,
back
sure,
on
and I get that. And I'm also acknowledging, as Ms. Swindle did earlier, that included in the written record and the things that she brought forward has been the judge's order. And the judge's order was really quite comprehensive in the issues that were being raised, and those things are being spoken to. She also included in the written record responses on the various aspects of the writ and the process. So that is part of the record associated with this. So, you know, again, I'm just asking for some equity on that. So this most recent photograph here has happened since the construction began on the site. I'm just pointing out here that basically the things that I'm speaking about today are tied to, and I'm pointing out that these things are violating the land development codes as well as statutes, particularly the 330, as the statutes that say that the most restrictive regulations apply when we're talking about governing our airports. That is clear. There is really no wiggle room there, and we're looking for that strict adherence. The violations of due process, the proceedings are tainted. It's basically irredeemable. It's hard to make a decision on this. The presumption has expanded since the judge's ruling as they are building the site. The harms that have been spoken about with site suitability are actualized, and there has been issue with retaliation and targeting. So again, in the LDC, what we're concerned with is the compatibility, which is a key component, not just in the land development code, but in the administrative code as well, because the site has to be analyzed in terms of what kinds of harms are being put on others. And in this, I'll say that there are harms being put on the people who rely on RSW being a safe place that's governed with integrity and is not plagued by violations of FAA rules and ignoring clear guidance. That there have been many prohibited and ex parte communications in the influence, not only through the board, but also at the Lee County Port Authority. And that's what we're speaking about, right? We're speaking about this FAA nexus here. And that basically that the hazards are being expanded at the airport. They're not being reduced by having this wastewater treatment plant there. These assets are our assets as a community, everyone's assets. And so the liabilities that come from that, including our ratings about how that we're viewed nationally, so that when we want to improve our airport to maintain safety, are compromised. Again, we have the conflicts of interest that are very obvious, and the ethics that are playing into this, because this is not the first instance of the FAA rules being ignored. When we talk about the previous history, it really goes back to the site suitability. This site was not a good site. It basically goes back to 2017 when there was a good site and that was being swapped out. And that's put us all in this pickle.
I'd like to object.
Yes, again, site suitability, once it's before me, I need you to understand, I cannot make a decision today that tells the board anything relative to whether the site was appropriate or not. That is not one of the criteria for my review, even if this was a brand new zoning case, but especially because we're on remand. I have very limited scope here, so we do not have a lot of runway, and not to have a pun, but we do not have a lot of space here. So I really do need you to shore it up. And again, I'm not making a comment on whether your comments are valid or warranted, or I think they're just misdirected to me at this point. I cannot give you any relief on this. So what I need you to do is please direct it solely to the FAA circulars.
Sure. And so the presumption is that this site has been in defiance of the judge orders. It's stirring up dust, and these things are being actualized at this site, increasing the hazard of this within the 5 miles of the airport. In fact, 13,000 feet from the airport, and I would dare say there's so much change that it is infringing on that 10,000 feet. So when we take a look here, you see this massive construction taking place, all of this atmospheric disturbance, the changing of the water flow. This has happened since the judge's ruling came out. So though the judge had pointed out that these guidances should be, they're not just strongly recommended. You know, these things should be followed. We also have contractual obligations with the airport as well. When we accept federal money, we are basically agreeing to follow the rules. So it goes beyond just the fiefdom of RSW. We have to think about what is our cooperative community doing in all transparency to protect us all. So we have enormous amounts of water all around being generated by the dewatering in every direction, impacting neighbors, increasing flooding risk, and it's any alteration within that airport proximity. All right, so if we're increasing the amount of water that's being shepherded from one location to another, because this is a major nexus of two prominent geological features, two physical features, that we are going to be affecting and altering. And when you do that, you're taking on that liability. So we have historical flooding here. We know that this is an issue. We know that these wetlands are attracting wildlife into the area. This is an area that already has a lot of wildlife. It's a conservation area. When you alter it, you're taking on that liability. It was existing, you just adopted it. These are all the reports of flooding, and this is reported also to the South Florida Water Management District, their resilience app as well. From 2024, the worst flooding that the folks over on Green Meadow and on Mallard ever experienced with water over their road. They called natural resources. These are the flood gauges from when they came out to document this flooding. So when we characterize, when we take a look at some of the maps that have shown this site, we see that it has been characterized over and over and over again as conservation area. So, it's been called agricultural, but over and over, this area has been noted for its conservation value, which is in line with the FAA guidance. The guidances are clear in terms of compatibility, and they say emphatically, especially when you have the Port Authority and the Board of Commissioners are the same people, because it's not that way in every community. But when they are the same people, there is no excuse for not following the land use compatibility. And keeping it low density around the airport is the best way to go. Putting in conservation uses, if it's already low density, and not going in and altering it to add and take responsibility by altering, that is the way to go. And we are lucky here in Southwest Florida that we have so much land surrounding our airport, and we're not putting people in danger. But there has been a trend to not want to honor these advisory guidances and to try instead to find loopholes. And the folks that are supposed to be protecting us are increasing our liability and putting us at risk. So why is this such a problem? This is the Immokalee Rise, which is the major physical feature in this region, and it runs into the southwestern slope. The southwestern slope is on Site 90. This is the major physical feature. There is so much water moving through there that this is the absolute wrong place to put it. It is a dangerous place to put it, not just for the people at the airport, but for us as receivers of this.
So again, I don't want to continue.
I realize that.
But you're getting back into site selection, which is not something we can consider. So the real
Sure.
issue that the judge issued their order directing that we consider the FAA circulars that were specifically mentioned.
Correct.
So to the extent that those do not apply, it sounds like based on the testimony that was provided, because this is outside of the realm. So the factual issues that should be directed is whether it applies or not. And so unless
Yes.
you've got some evidence that
I do. And in the advisory guidance, it states emphatically that you should find another site, right? That you should not put a wastewater treatment plant within the 5 miles of the airport. Emphatically, find another site. That's what it states. So when we take a look at the Alico Road study, again, we're seeing here that this area has the Panther. This is from that Alico Road study, and you will see that the airport property pretty much gets right up next to Site 90. If you take a look right there, you will see it. See the proximity. This is going back in time. All right, again, we can find a lot of useful information from the historical documents that Lee County has produced that show that the compatibility with this project at this location is a no-can-do. This is Lee County's own documents informing the decision about compatibility with the airport. These are the Panther telemetry, and you can see that there is telemetry on that site and the Panther deaths. Again, this is from the HEC's recommendation previously, and there are omissions. When we're omitting key information from our advisory documents, from our staff reports, from our testimony, it is a problem. It really is. There's ample evidence of what the surrounding land uses are to this property, all right? The surrounding land uses are not agricultural. We see that. And if they weren't changed to environmentally critical, that is on Lee County. It's not like folks have not appeared in front of them asking them to recognize those properties as being environmentally critical.
Right outside of the scope.
Right, and I'm pointing out again, Ms. Swindle, and I thank you very much, but this is a lot about the compatibility with the airport compatibility. That is why we are here, ma'am. When we take a look, we see that people are impacted, that when the site consideration for this facility began, that...
Again, I apologize. You need to stop talking about the site selection. That is not something that I have the ability to issue any kind of recommendation on today to the board. That is the bounds of my jurisdiction. I cannot go outside the scope of that. So please move on to something that relates to the FAA advisory.
Sure. So when we look at property 3, it is right by the airport. These are the hazards that are being increased. These hazards are being increased by this proposal that is incompatible with the FAA guidance. It's clearly incompatible. The flooding in the area also increases the hazards. In terms of other hazardous things going in by the airport, I will point out the previous history on how some of the zoning has changed in this area. So we do not want to compromise our public safety.
I understand, but again, other properties especially are outside the scope of what I can consider today, so we need to move on.
Yes. So basically, when we take a look here, the most restrictive, again, it's controlling. We have to look at the history of problems at the airport and the decision-making that's come out of there. We've had multiple people who have left their job. It has been continuous scandals. And again, when we take a look at, this is a link, ma'am, you can check out all these accidents. It gives you the rundown on when these accidents happen at the FAA, right around the airport. Here recently in Louisville, we had businesses, people around the airport, engine dropped off. These things happen. So there are absolutely legitimate reasons for making sure that we pay attention to airport compatibility. It is not a matter of broad discretion. It is a matter of strict adherence. Your own code says that you will adopt the new guidances that are coming in and that you will adopt the most restrictive that is available. And that is not what I'm hearing being proposed by your staff. Again, when this came up with changes to the LDC, when this was being discussed, when these things could have been adopted, and a member of the public said, hey, what about these FAA requirements? You know, people raising questions about public safety, about the way that the ponds are being managed with the steep banks and the littoral zones, decreasing the water quality protections for people who are downstream in order to put a wastewater at a site that is chosen bad is a bad choice to have the site there, because the water quality protections are diminished for myself and my neighbors downstream. That is directly tied to these FAA guidances and directly tied to Lee County choosing not to protect the public, which is their responsibility. Hundreds of millions of dollars in mismanagement. Hundreds of millions.
So that, again, we could
Increasing our liabilities as a community.
need to move on. Thank you.
Again, FAA rules are not willy-nilly. We don't get to pick and choose. It's not the Outback Steakhouse. This is strict adherence and decision-making that is based on strict adherence to our codes and regulations. So within the 83,000 acres of the density reduction groundwater recharge area, there's literally no place else. This is from the Wild Turkey Preserve Management document, which was provided you in hard copy. This is a map that was produced in that document, a very good map. Best one I've seen so far. And we can see Site 90. We can see Site 90 in relation to these buffer zones, right? We didn't have to go creating one on the spot at the last hearing. If we would have done our homework, we would have come across this. Now, Madam Examiner and staff and the public, I will contend with so much change happening on the edge of the Immokalee Rise and the southwestern slope that the impacts of the water are going to spread into this 10,000-foot zone. Ma'am, if you will take a look here, please look across the road and you will see that on the other side of Alico Road, where we have water being dumped into the ditch that I provided you pictures of today, is within that 10,000-foot zone. These impacts are undeniable, and the county is taking on this liability. They are putting us in danger, not just with the 5-mile circling, which they're clear, do not put a wastewater plant there, but within this document that was produced back in 2010. This is historical evidence produced by Lee County themselves. that they have chosen to ignore. We have a road board, and we are in a position where we have to be patriots to protect our own health, our life, and our public safety. All of us. So what is being hidden from us? What is? I found this Jacobs report. This was not included previously as part of the record, but it's there. And so in that, we can assume that the groundwater at this site is at ground level. That's how much water is there. All right? And then when we take a look, this is from the geotechnical, we see that in January and February that the water table levels are between 2.5, 3 feet in January and February. We have so much water there, so much. It's going to impact well within that 10,000 foot perimeter. Also, we'll point out that when we're talking about wastewater and we're talking about the beneficial reclaimed use, which I'm going to get into next, it's loaded up with PFAS.
And this is
It is. So
the outside.
it is. And I want you to take a look at this because this is from your own document again. These are the wetlands, all right? And then part of that report shows the future plans for the reclaimed water, which they did not share with us. And I asked specifically, I said, what about putting this stuff on the wetlands like y'all said you were going to do? What happened to that idea? Crickets. I asked. That question was not answered. It was not answered. But we got some scenarios. Let's take a look at it right here. Let's pipe it up and spray it all over the wetlands, right up by the airport, right up all over the neighborhood. We got 3 scenarios here. We got 3A. There we go. Distributing it, spraying it everywhere.
Madam Hearing Examiner, I can't say this enough. You keep going way outside of the scope of this.
This is coming from your plant that you say that you want to put there, that we're supposed to be looking at.
But again, it may be warranted, but it's not relevant today because what we are here today on is solely the basis of remand. I cannot consider. So even if, let's say everything that you are saying is 100% accurate, I don't have any legal ability to do anything with that based on what I have. My direction is to review the 3 things that were given to me, make a recommendation to the board, and then they will consider those things and make their decision.
I'm just pointing out all this alteration within the 10,000 foot buffer. That's
I'm
all.
not saying it's not warranted to point it out, but just not today and not here. I'm sure there are agencies that could do something with this, but at this stage of the zoning, there is nothing that I can do with that information.
So I'm just saying that strict adherence to the land development code and the regulatory guidance in terms of what is not only strongly recommended by the FAA and required by statute, but also in place here locally for us to keep an eye on. And we've got to keep a pretty sharp eye, eyes wide open at the airport with what's going on over there in order to protect ourselves. So here's one example, but there are others. And all of these things do impact the area around the airport and increase hazards. Again, looking at who's being served by these facilities. That we've heard the narrative with the conversion as why this site would be the place to put it.
Again, we're getting into site selection, and the demand
Sure.
was something that was demonstrated at the first hearing. So there's record evidence that supports that there was sufficient demand to warrant a site, a facility. So the site selection is outside the scope of what we can discuss.
I understand, and I understand that you're constraining the record naturally, because the judge's order also pointed out the presumption that was brought into this and the bias created by the Kingston development that is within this area of the DRGR and speaks to the demand.
As a hearing examiner, there is nothing I can do to offer you relief on that point. So what I am tasked with is solely based on the land development code and as
Sure, and within the land development code, there are parts about unauthorized communications as well.
Again, I don't have authority to litigate that or to issue any kind of a ruling on that. I am limited solely to the criteria that's set forth in 34-145D in this case. That is what I'm confined to, and even further to that, because we are on remand today, I'm confined to what the board has directed me to do. So I need you to move on and not just say that you're going to move on, actually get to the relevant points that are going to be discussing the FAA circulars.
Right, and so what I hear from you, hearing examiner, is this: there is no way to. I've previously brought through the presumptions and the ex parte communications, and those were brought up last time, and they are still relevant, and they are even more so than ever because they're actually over there building this place. That I cannot bring that up, even though that's in the judge's order today. Is that what you're?
You may be able to bring it up somewhere, but not to the hearing examiner. The hearing examiner in Lee County does not have authority to make a determination whether there was ex parte communication or not, and if there was, to issue you any kind of relief to resolve it. So that it may be something that can be raised, but not here today.
So within the land development code, there's nothing within there that speaks to ex parte communications?
There is, but that's not under the jurisdiction of the hearing examiner.
To enforce the land development code?
I don't have.
Or to make decisions based on the land development code?
Not specific to that. If you look within 34-145D, again, that's where it's relative to the zoning request.
Okay.
And so that is where my authority lies.
Right, and I appreciate that. And I also would just like to take just a moment to say that I also understand that a really important part of your role is also looking at and making determinations on whether keeping the zoning the same maintains a public purpose. And so I'm presenting this information to you so that you can please see that maintaining this zoning helps protect our water, it helps protect our flooding, it helps keep people from being in an unsafe place on an airport. It gives us direction in terms of how we manage development in our community. So again, I think that when we talk about the scope of making decisions, that we look at the information that Lee County has put together in their guiding documents, informing these wastewater sites, and this information on the package plants and the settling ponds, the aeration, spraying the reclaimed water, help inform what's going to be happen or may happen with this plant down the road. Again, there's a lot of seasonal variation in terms of what this wastewater plant's going to be managing. These long pipes are going to make it less.
Examiner, again, we're well outside the FAA regulations. If you have a point to make on those regulations,
Sure.
please.
Yeah, so there's going to be so much water that's infiltrating these pipes that they're going to need to spray it all over the place to get rid of it, because we're talking like 10 miles of pipes, and all of the water going into it makes it less efficient and more dangerous for everybody because they're pumping it in on a place that's next to the airport. So how can we, if Lee County is the applicant and the decision maker and the Port Authority, right, that's a conflict of interest.
Object again.
And we just went over this. We were both saying the same thing.
Sure.
Repeatedly. But I need you to actually move forward and not continue to try to put these things into the record, or I'm not going to be able to accept what you have provided.
Right.
We have not made the nexus between the FAA circulars and your.
Sure. And so I'm just going to go back to the circular just a second, because I think that some of and I could tear apart the exhibits. I don't think that they were really put out there as in good faith in terms of representing the area of operations, for instance, on some of the maps, or choosing to minimize the seriousness of the situation. Showing like the takeoff zone and this and that is not fair. That's not representative. That doesn't protect our public. And I'm just going to call out those mischaracterizations. The Land Development Code asks that these things be amended. And so it's a responsible and cooperative thing to do, to work in cooperation with our state government that puts out statutory regulations, and our federal government that puts out regulations and also helps fund us whenever we have hurricanes come into the area and completely destroy things and flood it, and then it's moving south towards our public assets. you know, we have to have this cooperation. We want the federal government to keep sending us money and to not get into a situation where it's like, whoa, you know, are you in good faith, Lee County, implementing federal guidance here? Again, hey, we had a place for this plant.
I object.
Voila, here it
We're
is.
not here to talk about 2020.
We need not site selection, as I've said, so I need you to move on. Thank you.
Yes, well, I'm basically just pointing out, we got a great couple of great places right here that are not within the 10,000 foot part of the airport, right? Like it's not within right there, water's not going everywhere, 5 miles.
Thank you, Ms. Ellis.
Yes.
A lot of this was also presented at the initial hearing, which is already part of the record. So you don't need to reiterate things that were already covered. That is already been incorporated by reference.
Great, yes, and so the property site 90 has been called agricultural, but this is like the perfect example of an agricultural plot right here, which was an orange field, touted as restoration that never got restored and got a development put right across the street from it on Corkscrew Road to accommodate the developer.
Objection.
Oh, here I am. So this is when I found out about this whole thing, right? So I found out about it, and my words at that hearing were, this cascade that will come from not bringing us in here to talk about this and put these things on the record will continue on and on and on.
I need you to please move on. Thank you.
Yes, I'm so happy to appear for you today and share my concerns about the airport and these guidances and the way that this county is being managed. You're welcome. All right, so we can take a look right here. You can see the airport property right up there at the top. Just, it's like poking through. I can see it. It's not marked off on this map, but it's right sort of up there towards the left. Yeah, there we go. So again, you know, in evaluating not just the impact of the 6 MDs or the 10 MDs, those are all being underestimated. The
Outside of the scope.
forever expanding facilities here. Oh, this is so helpful. So this was actually in a handout that Ray Blacksmith, he's contributing to this education for us today. It shows the developments. It also shows the 2 panther crossings right there by the proposed sea wharf. And so this is a really informative map so we can evaluate the wildlife in the area, make sure that our wildlife are compatible. So since there have been many times that there's been a lot of robust discussion and agenda items that have been brought forward in front of the Board of Education.
I need you to please move on. I cannot offer you any relief on any of these allegations, so I need you to please move on.
No, so basically, you know, this thing was approved and without the judge ruling and us being given our justice and procedural due process, or the people of Lee County having the opportunity to, you know, have an airport and a county government that basically follows the rules, that there have been items that have appeared at the BOCC lots of times with the in regard to the airport too. In fact, we're missing an airport meeting right now. So there is a conflict. There's an airport meeting, and we could be there sharing our concerns, but we're not. We're here. So again, you know, when the county,
That point, ma'am, again,
yeah.
You just said it, and I appreciate you saying it. Following the rules is extremely important. It's very important to me. I am an attorney. That is what I am charged to do. I took an oath to the state and to my job, and I take it very seriously. I need to follow the rules, and the rules do not allow me to consider the things that you're speaking about. And so again, I want to ask you to please bring it back to what I can talk about, which is the FAA circulars. And I think you can recognize these things are well outside the bounds of that. So
Well, so, you know, being able to participate in my local government is really important to me. Being able to appear before you today is very important to me. Being able to speak out for myself and my neighbors, all the people who think that they're flying into a place that's safe. being able to speak out for them is so important to me. And I know you respect those First Amendment rights. Unfortunately, I do feel fearful.
I'm speaking. Thank you. I also respect procedural due process, which is being provided because you do have the opportunity to be heard today, but you need to be heard on the items that we can consider. It is not a public comment free-for-all. That is not what today is for. So I appreciate the comments you're providing. It's not the appropriate venue to do that. So I just need you to please bring it back to the items that we can discuss today.
And so, ma'am, the judge's ruling is very, very broad. And the judge speaks on multiple issues. And I feel like I'm being unnaturally constrained here. It's also a bit triggering because I have had my First Amendment rights violated before. And if I just simply accepted everything that Lee County told me, then I probably wouldn't be here right now. But we have had broken promises time and time again, and things that were represented to us have not happened. And so, you know, it comes to a point where being put through this stress and being unnaturally constrained and having our First Amendment rights violated, our procedural due process, having prejudice and bias and presumption thrust upon us at no fault of our own is very stressful. So if I could just breathe a second, I would appreciate it. I just need to get myself together.
We've been at this actually for over an hour. Let's take a break and let everyone kind of take a moment. And I would just ask, please, and I hope.
I will wrap it up as,
Thank you.
if you want, I've got just a couple more points here, but
You want to take a break?
I think I do, if you don't mind. It's just been very stressful. It's been, you know, it's been years, and
I understand.
it's unfair.
Let me give you some time. So we'll reconvene. It's 10:14. We'll reconvene at 10:30.
It's in the temporary uses section of the code.
Okay, are we ready to get back on the record, everyone?
Yep.
Okay, we're starting back on the record. Thank you, everyone, for taking a break. We'll resume now with public comment.
Thank you, Madam Examiner. I really appreciate the courtesy. And I did have a chance to take a look at the notice, to look at that language, and it says specifically the case has been remanded to the hearing examiner for the limited purpose of addressing findings of the 20th Circuit Court in the order dated October 25th, 2025. I just wanted to point that out.
And did you review the order? Because that's
Yes.
where I'm getting my direction.
Yeah, the order from the judge.
Yes, and then
Yes.
the board directed me based on that, so I'm downstream.
That's right, and that's kind of how I feel too. I feel like I got into the cattle car and now I'm getting my chute shrunk, and that's not really,
It's the legal process, unfortunately, so I just want to continue to remind you that is what I'm constrained to do. And the first 2 points of that really speak to, again, what I said, they're kind of couched together in terms of confining the record to what has been presented for this case. And then the
Right.
third point really is the new information of the FAA. It's not new, but it's the
Right.
direction to review the FAA advice.
I also want to not see that the county walk themselves into a procedural due process issue and make sure that the essential requirements of the law are being honored as well. So basically, when we take a look when we talk about the planning process, I just wanted to point this out, that if faithfully, that there are.
Objection, Your Honor. I mean, Madam Hearing Examiner. It's been a long morning.
Yes, thank you. If you can please move forward. This would be outside the scope of what we just discussed.
Sure, that I just am pointing out that, and I do appreciate the courtesy that has been shown to me, that I understand that there's the interface with the public and the public interest, and making sure that things are represented in a fair and unbiased way, and that there are expectations that things are represented in a equitable, full disclosure, that there aren't omissions and mischaracterizations, and that withholding information or trying to constrain things or ignoring parts of the land development code, because competent and substantial evidence, I think we know it's important, but there are other things at play too. We can't just cherry pick information and ignore the other parts. I mean, we're all here today in response to this notice. People have given up their time from their work, their jobs, to participate in good faith on a very serious issue. I mean, the order from the judge was very telling, and I think that we all want to learn from that process. And with that being said, part of the big issue at play here has been the conflict of interest.
Again, this is not something that's before me for review, so I would ask you to please move on.
Sure, I know, but it was a big part of the judge's order, right? And that's what the notice says. I'm just saying, I'm a member of the public. I expected to be shown the courtesy and show up here today and share based on what the notice said, right? Like, I literally looked at it, I shared it, I made copies, I gave one to my husband. We just reviewed it again together, and that's how we prepared our information, our testimony, and what our expectation was here showing up today, right? Was based on the notice that the surrounding property owners, my neighbors, were sent, and that people who didn't necessarily even participate in the last hearing had the opportunity, right, to show up here today.
Absolutely.
Yes, and so, and they read the order, and they know what's on there. I read the order, my husband, my neighbors, we all read the order, we know what's there. And so the concerns about the influence and about who's being accommodated and the lobbying and the ex parte are part of the order. I'm just saying.
They're not part of the direction to me for remand, though, and so.
Correct.
the hearing
I'm just responding to the notice and what was in the notice, right? Because, I mean, I've got other things I could do with my time. For sure. I'm responding to what's in the notice.
Yes. So if you could please move on to that.
Yes.
I can consider.
Again, we have a lot of conflicts of interest that are going on. And then when we ask ourselves, the county approval of the county as both the applicant and the decision maker
Objection.
is a big part of the issue in the order that I prepared these materials for and I responded to today, that demands higher, not less scrutiny. And that includes communications that have taken place with the commissioners and folks who are named in the order, right, that I responded to and prepared these materials for. I understand that you were operating under constraints that you've sprung on us out of the blue without us knowing about, because we were responding to the order, right?
I apologize that you feel that way, but to again reiterate, I am operating under the direction of the Board of County Commissioners
Sure.
remand of this case, which was limited in scope to the 3 identified items that are in the judge's order. And so that is what we were discussing. And
Well,
of
those-
3, ma'am, I'm speaking. Of those 3, the 3rd item is truly the one that is relevant to the testimony today, because the first 2 are outside the scope of anything that I can do beyond reviewing the record and ensuring that my recommendation to the board was based on competent substantial evidence that was in the record for this case. So whether
And I get that. And, you know, the fact is that the decision makers, when you have both applicant, this is not, you know, you have both. We have both applicant and decision maker. And when that happens, these things get married together. And so unfortunately, I don't believe that they can be separated. And that's why I'm saying that I think that this is being unnaturally constrained, and it certainly was not was portrayed to the public. And we all have a responsibility when we have these interfaces with these decisions that impact us, impact our property, impact our health, impact our safety, impact our faith in our government, right? That we have the opportunity to be able to participate in good faith as it was advertised to us. I'm asking basically for folks to recognize and separate out what their roles are, because there has been a whole lot of mixing and matching. Right? And if a staff member is putting together, if they're both the decision maker and the applicant, and it's the same people, and then you have to have more separation. You cannot be confusing these legislative and these
The speaker has yet
roles.
to address the actual merits of this hearing, and I don't believe anything that she has said on the record has done so.
Ma'am, I'm going to,
And I would request that her testimony be stricken to the extent that it has not addressed the scope of this hearing.
I'm going to ask again if you can confine. I understand your I understand your displeasure with what we are discussing today, but that is, again, I am operating within the confines of what has been remanded. So I need you to please address your comments and limit them to the relevant testimony relating to the FAA circulars.
yes, ma'am, and I'm responding to the notice that was sent to the public, and I will also say that I think that the maps and the information that has been brought forward about the real risk to public safety in regard to the actual measurements that have been put forward by lead government on other documents do have relevance, and I think that the evidence that's being brought forward is in the public interest when the staff and the decision makers and the government fail us. Thank you, ma'am, for your courtesy.
Thank you. The next card I have is for Serge Thomas. I'm sorry, Dr. Serge Thomas. Good morning, sir.
Good morning. I am Dr. Serge Thomas. I also live on 17850 DeVore Lane, Fort Myers, Florida 33913, so not too far away. I'm a aquatic ecologist, and I really come here to speak about as a scientist. I study mainly water quality, especially related to nutrients. I have experience working with wastewater treatment plants and issues with water quality as well. I come here today, I canceled my class just to be here in response of the notice, and I thought I could really express myself about the issues I have with the site and the water quality, and eventually a health risk as well. Because my work has expanded not only on nutrients, but also on PFAS and other xenobiotics, so toxicants that you can actually have after the water has been treated in a wastewater treatment plant. Right, so the first thing I would like to say that the location is definitely not a good location because it is at the confluence.
I know you.
I understand that.
I recall your testimony from the original
I'll,
hearing as well.
you'll let me speak and I'll be brief. It's at the confluence of a flowway right? And it's going to be a problem when there is a lot of water moving through it. The other issue is that there was no real mention of the Jacobs Engineering reports, which I read, and I was totally appalled by the way the water was going to be used after it's been treated by the plant to put it into wetlands. So I actually work in wetland protection as well as wetland filtration, and I can tell you that this is a really bad idea to use the effluent and to release it into the surrounding wetlands. You're risking long-term pollution. The treatment plants are not designed to remove PFAS and other contaminants which will accumulate and eventually infiltrate into the superficial aquifer. And you have a lot of people around that rely on that water for drinking. The other connection that was not made is a connection with the Kingston development, which is 10 miles away. I also have experience with leaky pipes from wastewater treatment plant. Here we're talking about raw sewage going across the DRGR. Two problems. One is it's a long length of pipe, a lot of infiltration into the pipe because they are not sealed.
And again, I believe that was testimony that if I'm recalling from the first hearing, so that's already in the.
I didn't know that at the first hearing that we had connection with Kingston. So this is new information to me. In terms of if there is a hurricane, you're going to there is no elevation to help us to move that water so far away. So you might have some issues with water stagnating, backflushing, and eventually getting into the wetland, polluting as well the superficial aquifer. So not a good idea to have this as well. What I really recommend is to find another suitable site and eventually to be.
It's not relevant to the FAA circular.
I believe that when you're building a development, you should look first at reducing the length of pipe, and I think that Kingston should really look where they could put a wastewater treatment plant that would be closer to where those 10,000 homes will be built. So there is a little bit of an environmental injustice here because this is mostly a rural area. I'm not sure to who that wastewater treatment plant is going to serve. It doesn't seem that it's going to serve the people surrounding it at all, and it's going to bring a lot of disagreement and eventually potential pollution to the neighbors. Related to the FAA, if you just, now we're into the era of AI, and you just ask a question, is it a good idea to put a wastewater treatment plant next to a airport? And you'll see all those development, and there is a long list. It's not a good idea. And as Marsha Ellis mentioned, it's not only the takeoff and the landing. There's also, if there is a busy traffic, they're going to have to fly around for a little while, and they are going to intercept the place where we're going to have the wastewater treatment plant. So again, I totally opposed to the idea to have it there. It doesn't make a lot of sense to have it there for all the reasons aforementioned, and I stand by this.
Thank you.
Thank you.
Thank you for coming today, sir. The next card I have is for Peter Spahn.
Good morning. My name's Peter Spahn. I live at 17100 Wobegon Drive. I'm the home closest to this site. I work for Soil and Water Conservation and did drainage work, Department of Agriculture surveying, and agricultural site or waste management. Most of my objections are about site conditions, but I won't get into them. One thing, today it was mentioned it was a 10 million gallon a day facility. I've seen it multiple times as 6, 8, 9, 10, and even 15 million gallons a day. I'm wondering what the actual number is. Is it an ever expanding number? Is there expandable capacity for the plant? I think this hearing is premature, and should be a de novo hearing. It was quashed and then not remanded. I'm still awaiting to hear the results or report on our initial remand from 2017. And, you know, this hearing shouldn't even occur until after the appeal is concluded. So we know where everything stands. Once the zoning was quashed, the work should have been stopped immediately. But they got tens of millions of dollars that they're spending already. You know, their presumption of approval. And everything else I have to say is about site selection. And this should be a de novo hearing. Thank you.
Thank you for coming today. The next card I have is for Lori Sandville.
Oh, I think she might be with Vulcan, and I think she left.
Okay. Thank you. Next, I have Derek Felder.
Derek Felder for the record. Not a neighbor to this development. I am a Lee County citizen. Based on what I've heard from previously on this development, based on what I've heard today, I'm in support of this location, this use, and the changes presented to place this facility here.
Thank you. Next, I have Julia Lambert. Good morning.
Good morning. Hi. So, actually, before I start, let me just have my phone out. Trusty phone. Okay. Here we go. Hi, I'm Julia Lambert. I live in Wild Blue, and a community, a large community, fairly close to the proposed storm wastewater plant. So, obviously, I'm not an expert, as in these folks and so forth, and everyone here, but as a commoner, so to speak, and obviously it was in the first Hex hearing. I don't know if you remember me. I had that famous quote. It was the Spider-Man quote: "With great power comes great responsibility." I'm a huge Marvel fan. That's why I put it up. But anyway, that particular quote is very important, especially here, right? Because for obvious reasons, you have a conflict of interest situation. You have the people that write the rules are trying to enforce the rules, and the boards, you know, BOCC and so forth, all the conflict of interest all over the place.
Objection.
So I'm just saying, basically, this is speculative, but however, it is a Nick Swirly event, so to speak. And I know everyone watched the news, so to speak, just from a press standpoint. So from a commoner, such as myself, if I just get on the phone, everyone Googles, everyone has AI these days, right? Either you use chat or Gemini. If I just Google, using Gemini, saying, please provide the arguments against placing a new sewage facility near an international airport on a sensitive flowway in Lee County, and centered around safety and concerns and so forth.
Madam Hearing Examiner.
No, I know, I understand. But the very second point that it comes up, when you mention that, it breaks down to three categories when you enter that, right? Aviation safety and wildlife hazard. Second one is environmental impacts. Third is legal and procedural arguments, right? Going to the first bullet point, right? Under that, the first point that they brought up the FAA noncompliance, right? This goes directly to what you're referring to, the advisory. So you should love this conversation, right? When they talk about this, right, it strictly says Federal Aviation Administration, FAA, guidelines strongly, they use that adjective strongly, recommends a separation of distance of at least five statute miles between airports serving turbine, aircraft, and wildlife. And a facility placed just outside the buffer may still attract hazardous wildlife and critical flight paths. And then when you actually go into the advisory, which I did, and I just literally, I was at this meeting, I sat there, I Googled it, it took me 10 minutes just to do this. I'm saying if it took me 10 minutes, any reporter out there that actually makes a dollar, or independent reporter, or even a nonprofit reporter can do this too. So excuse my ignorance here. So when I go into the advisory that you're so referring to, it's the first section literally says, okay, uses words like strongly and so forth, and I actually printed it out. Actually, I have it on my phone. It says, blah, blah, blah. It talks about, in the very first section, section 1, page I2, intro, right? And you can continue writing. 1.4, protection of approach, departure, and circling airspace. This goes to Serge Thomas, what he was referring to, not just in the direct path, which you guys referred to, but it also relates to circling, because we all know now that Fort Myers has grown, and given the influx and the increase of the growth patterns that Southwest Florida is experiencing, we should, and that's the whole reason why you guys are expanding out our airport in the first place, we should expect more growth. So let's speak. So circling patterns is not not a foreign concept to most. Maybe to some, but not to most. Right? So when we refer to the advisory, it says literally, for all airports, the FAA recommends a distance of 5 miles between the closest point of the airport's operations and the hazardous wildlife attractions. Right? And then it says special attention should be given to hazardous wildlife attractants that could cause hazardous wildlife movements into or across the approach of the departure airspace. Figure 1 depicts an example of a 5-mile separation measured from the nearest aircraft operation. Right? It gives you just an example. It doesn't mean it's not like the Bible where it says like you have the Bill of Rights. I mean, the Ten Commandments or the Constitution, or the Bill of Rights, but an example, which is subject to interpretation by the best of us, so to speak. And in an example, it gives a whole. I don't have the. Sorry, I didn't bring up the slides. I would have, but because I did it in 10 minutes during this speech, bear with me. I can actually print it out for you and give you the pictures. It gives you an example of the aircraft, of the airport, and the 5 miles around it. And it literally says in there, perimeter C, that's where we are right now, because it breaks it down to perimeters, A, B, and C. Perimeter C, recommended for all airports. There's no exception or qualifier for Lee County because of the BOCC and so forth. There's no qualifier there. It says all airports. 5-mile range to protect approach, departure, and circling airspace. So that's the intro in 1.3. Now if we move on, within the advisory, the documents in which we're being restricted to talk about, which we can, because in 10 minutes we can talk about it right here. When I go into that advisory, I look at page, all throughout the advisory, section 2. Okay, page 2-3, section 2. There's at least 4 spots within that advisory that uses strong adjective words like against. Words like all and against. I'm not sure if we all speak English here, but I know we do. From a legal standpoint, words like all and against is pretty strong. So if you have an argument against the advisory, it better be rock solid. It should be like bulletproof. And if it isn't, you should listen to the advisory. At least that's from a layman's viewpoint. Not from a legal standpoint, nor from a planning standpoint. From a layman's standpoint, you should think of it from that point of view. So when I go to section 2.23, the subsection says, consideration for existing waste disposal facilities within the limits of separation criteria. And it says, specifically, the very first sentence of that subsection, it says, the FAA recommends against airport development projects that would increase the number of airport operations or accommodates larger and faster aircraft near landfill operations located within the separation as identified in the intro, which I was talking about with the perimeter. And then the section in the very bottom of that page, right, it's section 2.26. It says under the subsection titled underwater waste discharges. Obviously, it's a sewage facility. The big thing is underwater waste discharges, right? And I'm speaking plain English. I'm not speaking in terms of statutes. I'm speaking, if you just Google it, Gemini, you got it. Plain English stuff. In that thing, and I highlight it in yellow, the words. It says under that subsection, underwater waste discharges, it says the FAA recommends against, another word against, the underwater discharge of any food waste within the separation identified in paragraphs 1.2 to 1.4 because it could attract scavenging hazardous wildlife. And if I go even further, there's another section, and it goes on. There's another section that it says it should be, there's words like should be avoided to prevent wildlife attractions and so forth, and blah, blah, blah. And there's like at least 4 other sections in that advisory that everyone so loves. So what I'm trying to say is, like, you can find exceptions, just like when you're in law school. When you're trained to be the best of the brightest to be in law school, what are you trained on? You have an argument, you have a position, you have to say your pros and your cons. You have to be able to defend both sides of the argument. Agreed? So these planners, right now you're in a precarious situation where you know there's a lot of eventness. You know that the scrutiny on this is going to be very high because of the conflict of interest in this. But when you have an advisory, a federal advisory that says, uses strong language like against and all, and strongly advise that, you know, how do you discount that? Do you discount that with degrees, planning degrees and legal degrees? I'm not sure, but you can. You probably will get in trouble because of that, because it's very clear of what they advised against. And from a layman's term standpoint, it's very clear the reasons why. So going forward on that, and then also another thing I brought up in that when I was here in the very first time from the HEC standpoint, another thing I Googled, I just Googled this too. Okay, I just Googled this. Where's my picture? Oh, here it is. Okay. When I said, okay, let me just Google this. What's the rating for Lee County's water management by the rating agencies? It says Fitch. Fitch is the only one that's rating it. Fitch affirmed in Lee County, Florida, solid waste revenue bonds of AA-, which is stable. But keep in mind, that stable profile, which was affirmed in 2023. Congratulations.
Objection as to why solid waste revenue bonds.
No, I agree. But however, this relates to the fact that from a water management standpoint, FAA, the advisory specifically refers to waste facilities and water management. And the fact that that advisory is strictly saying they recommend against doing so, and given our ratings that happened in 2023, and given that currently we're in 2026, 3 years later, you do agree that it probably will be reassessed, the ratings, so to speak. So, but that AA rating says that what it means, a AA rating, shouldn't be discounted, right?
Objection, solid waste is completely outside of the realm of this here.
I believe that was discussed also. I
Okay.
remember that testimony.
Okay, that's fair enough. So now, so now let's go back to the original. If you just Google it with Gemini, which now obviously is related to Siri, so now it's even more important, like as far as like AI stuff. Remember I went back, there's 3 categories that when you just say, okay, what are arguments against putting this facility? And obviously one of the main arguments that he brought up is the advisory that you guys are trying to restrict us. And I just went through my reasonings behind that. So when you go into the third argument that they specify, in the violations of legal and procedural standards, obviously a lot of stuff was already brought up in the appeal that because this thing was squashed, and now we're in remand territory. The last bullet point of that, it says failure to follow internal codes. And it literally says, courts have ruled, you can Google it, courts have ruled that Lee County must follow its own land development codes and FAA rules with the highest scrutiny, rather than basing decisions on a predetermined board directions. Highest scrutiny, those are big words. That word highest is the same word that's also used in an advisory that we're referring to. So what I'm trying to basically say, for obvious reasons, is tread very carefully, because obviously a case, this remand that you're restricting has a lot of event risk and it will be hit by the press. So in addition to having breaking all those things that Marcia had brought up as far as the headline risk, as far as putting in all these things that Lee County wasn't abiding by when they followed these airport rules and so forth, you're going to add this to the list. And now all of a sudden, Lee County will be in the spotlight, way more than other. And I'm just saying, and this is an election year. I know I'm digressing, but just tread very carefully. And I hope that you will tread to it, and you will take it to the highest scrutiny, which it should be, because you need to set an example for everyone else. So not just for the commoner like myself, but for all the constituents around us. Because obviously, we all know what the right thing is, and we all know the pressure, the economic pressure that's forcing you guys to do this. It's very obvious, right? Kingston and all these other. There's stats that says that 15%, the majority of the 15% growth in Lee County is coming from this area. So we all know the pressures of that. Just use the highest scrutiny and tread very carefully, because even if you accept this, if you push it through and go through the BOCC on this, I'm sure they're going to say yes, because they're going to push it through as well, because for obviously reasons, the conflict. Keep in mind, even if you don't get tagged this year, next year, this is all on record and it could come back to you. So the decisions you make now should withstand, under the highest scrutiny, should withstand for the next 20 to 30, 40 years. That's why we have a Constitution. That Constitution has withstood decades, and hopefully, now 2.5 centuries later. So those documents were written very squarely and very well for obvious reasons, and they weren't written by lawyers. They weren't written by planners with certifications. They were written at the time, I'm sure you heard this in law school, they were written at the time by our founding fathers, who were farmers, who were militia, who were various other common folks. And they were written in such a manner that they can be applied to 2.5 centuries later, and hopefully more so in the future. So what I'm trying to say is plain English terms that I just mentioned, using words like the highest, avoid very strict adjective words, should apply in this case, especially given the scrutiny of your position, your very important decision. And seriously, this will be the benchmark, because right now this remand, the squashing the case, if you enter in without it, if you just strip out the Lee County aspect and you just put Florida, which means that this is the benchmark case of what's going on right now. So if, not just for Lee County, but for all counties in Florida. So what I'm trying to say is stand by your conviction. Stand by who you are. Stand by the highest integrity, because your decision has to last on this one. That's all I'm going to say. Thank you very much for your time. I really appreciate it. And do you need pictures, copies of this? You can just Google it.
Circular, correct? I have it.
I just read it from the and I can print out the Google pages for you. Gemini?
It's in the testimony, so I'll have it in the.
Okay, perfect. I'm sorry. Thank you very much. I
Thank
appreciate
you for
it.
coming today. The next card I have is for Ronnie Canada. You don't want to speak, sir? Okay, then Kenneth Dow, or Do?
Kenneth
Do, thank you, sir.
Good morning.
Good morning, sir.
My name is Kenneth Dew, and so I'll speak on behalf of my wife, Anna Ortlieb, as well. We live at 17651 DeVore Lane, so it's near the anticipated facility site. I know that the purview of the Madam Examiners is supposed to be narrow, but I will say this, we are rather new in this area. We've lived here for about a couple years, but I'm sort of surprised at what's going on. So I will say first that I do thank Marcia Ellis and Dr. Thomas for their work. I'm very familiar with the stresses of litigation and the resources when you come up against a much larger party which has unlimited resources. With your purview being limited, there's one thing that you cannot escape, and I'll use, this is where my limited expertise comes in from our life experiences. I'm retired, I'm a retired attorney. I no longer practice law. But I spent most of that time as a deputy district attorney, and I have prosecuted hundreds and hundreds of cases, spent my time before judges in many courts all over. One thing that we cannot escape is the spirit of a court order. So I know everyone would love to look at things in a vacuum. And you can say, oh, we're only going to look at this one thing. But you cannot forget the context in which the court spoke. The court saw the bias, the court addressed it, and that's the viewpoint of the court. It is dishonest to ignore the spirit of the court order. And I think it's very disingenuous to go ahead and try and ram through what you want to do, despite the appearance of a court order. And that is continuing construction and development despite a court's order. I'm shocked. I know in where I practice, they'd probably be talking contempt. I know things are different in the civil cases because there's a lot more games that go on. But once you go into the contempt proceedings, it becomes criminal from a civil action. So I do ask that you respect the spirit of the court order, even though you may see your purview as being limited. Look at it through the eyes of the judge. And he considered the bias of both an applicant and the decision maker as the county. The bias is incredible. When you ignore the spirit of the court order, you do a disservice to the judiciary and the community that it services. It's that important. I speak in opposition to this facility. It's easy to see through, read through the lines, what's going on. Development goes on, money's made, but the residents were left there. Animals, they don't respect an imaginary line of 10,000 feet. Neither do airplanes. So I ask you respectfully, please respect the spirit of the court order. Look at it through those eyes. Even though you may have a limited purview, you still understand where the court came from. Thank you.
And I had your wife's card as well. Were you speaking for her, or did she?
Yes.
Okay, she's not going to speak today?
No.
Okay.
No,
Thank
she is here.
Thank you. All right, that was the last card I had. Did anyone else want to speak today?
I haven't had a chance to fill out a card, and I didn't have the case number.
Thank you. Okay.
I have spoken at this particular
Okay, thank you.
hearing once before.
Okay.
The initial one.
What was your name, sir? I'm sorry.
Britt Gladwell. I live at 18801 Green Meadows Road. Been there for 30-some years, and we have dealt with the DRGR quite a bit. We've lived there, told you have to deal with the inadequate water drainage plan. I understand this is about the FFA. Seems like to me the county has got caught playing favors in the DRGR and pushing certain agendas through and overlooked this. This is why we're here today. I think the Board of County Commissioners, the only way they can hold good faith is remove the DRGR, let everybody that owns property in the DRGR have the same chances to develop their property, and quit picking sides and whose agenda you serve and whose you don't. That's all I have to say.
Thank you. Okay, and then I have a card for Ms. Montgomery. Good morning.
I'm gonna hand the hearing center memo, and I'll give the court reporter my copy. Neil Montgomery for the record. And on page 2 of the staff report, it outlines the 3 points that were the basis of the board's remand. I want to focus on point 2. It says the circuit court found that previous board actions such as purchasing land, initiating prior zoning, and entering into the Kingston settlement in 2022 demonstrated prejudice and bias
And
for a
I-
predetermined.
but I need to treat all speakers the same. So that is not an item that I can provide relief on. So I understand, I read
Well, but there's factual and legal errors there.
in the staff report, so you're correcting. Okay.
Well, and my my point is, and there's been a lot of testimony here today, and there's been a lot of prejudicial testimony that affect my client, Camerata Properties. We had an exhibit submitted with Ray Blacksmith's name that was mischaracterized. There were photos of the place for Donna and misrepresentations about Kingston and a lot of testimony about site location. And I agree with the hearing examiner and with the staff that when the board approved the public facilities land use category for this site, it's gonna be a government use. It has to be. It's not DRGR, it's not conservation, it's not wetlands, it's a public facility. And then I also want to point out by law, which I think is important, if you look at section 163.3177, and this goes right to the heart of where the judge is wrong and the petitioners are wrong, and that is, it says, the board is obligated to adopt a CIP for a 5-year period. The board is also obligated to do a minimum of 10-year planning and 20-year planning. And the board is obligated to, in regard to public facilities, identify the need, identify funding sources, and identify locations. So the very things that all these people are objecting about where they've misled the court, the county is following the law. The court did not follow the law. And I have a copy, so you don't have to look it up, of 163.3177.
Thank you.
Where you can clearly see that it's a requirement. And in following the law, the county is required to do a capital improvement program. And the county has done that in Table 3A in the comp plan. So one of your findings that you have to make under 34-145 is consistency with the comp plan. And I'll hand you Table 3A.
Thank you.
And that plan, which is consistent with state statute, provides for this plan. So 99% of what you heard today is this isn't the right location. That issue is not germane. That issue has already been made as required by state statute. Concerns were raised about flooding. That's not an issue either. The county in Chapter 10 defers to the Water Management District in regards to environmental resource permitting. That obligation has been met. The county has complied with wetland permitting, water resource permitting, and drainage. So all the discussion you heard about flooding is not relevant. And the assertion by the judge and by these people that somehow Kingston was the driving force and there's bias and prejudice isn't true. And it's surprising to me that they have asserted that, because one of the petitioners during that hearing, before Judge Shanko, the same judge that issued this order, where we robustly discussed that settlement, she plumped herself in the jury box and had to be quieted several times by the bailiff. And there was a reference to the development agreement. So both the settlement agreement and the development agreement do talk about the fact that Kingston has to have central water and sewer. True. As hearing examiner, you know that that's an important requirement every time people come before you. What the development agreement and what the settlement agreement don't say is where the county has to provide a plan. True, the county has an obligation legally, by not just by 163, but other provisions. The county has an obligation to meet the central water and sewer demands of the public and based on Beaver projections. So we can all say we'd like people to stop coming, and so we can just not build things and pretend they're not going to be here, but that's not what the statute says. The statute says you got to use the mid-range Beaver projections unless there's some other reason not to, and you've got a plan for facilities. And the county started doing that in 2015, and they hired an outside consultant, so I know all this bias and prejudice. The county didn't rely on its own staff. It hired an outside consultant with expertise to objectively look at those issues, to study the demand, to study the amount of the demand, to study the timing of the demand. And then they did a due diligence on several sites. So the county did go through a site selection process.
But again, we're not discussing that today.
And we're not discussing that today, but my point is, we did discuss it today, or we heard it today, but that ship has sailed based on competent substantial evidence and professional engineering expertise provided to the board. The board made decisions, and those decisions then get reflected as required in the long-range public facilities and in Table 3A. So again, and with all due respect to some of the circuit court judges, they don't do land use. They don't deal with 163. They don't deal with these issues. So they can be misled. And in this case, the judge was, because the county would be violating the law if it did not engage in 5-year CIPs, if it did not engage in 10 and 20-year planning, and if it didn't properly look at what kind of facilities have to be provided. So the record shows 2015, 2016, the county, was evaluating, and in 2018, there was a hearing. And at all these points in time, there's public input. There was public input, as you know, through the LPA and the board when the public facilities category was adopted. There's public input generally when the CIP comes before the board, it's on the agenda. And several of the petitioners read those agendas and do show up and comment to the board. So the idea that there's illegal ex parte communications or some form of bias or prejudice by following the law is simply not correct. And in particular, as to the Kingston case, that went to the board and circuit court long after decisions were made on the wastewater treatment plant and that need. And again, there was a lot of public input. That settlement agreement came before the hearing examiner for public input and testimony. And the hearing examiner made recommendations to the board where there was another public hearing, and then it went to circuit court where some of the petitioners participated. So the idea that somehow Kingston demanded that the utility plant be located here is simply not correct factually, not correct legally. And in fact, if in the development agreement, it provides that if perchance the county can't build a plant wherever, that Kingston would be allowed to build temporary facilities. So it's clearly not the driving force for the plant and not the driving force for the plant in this location. So all those assertions that you've heard that were on the record before and now are just factually incorrect. And in fact, if the plant were built on Corkscrew, that would be better for my client because it would be closer, so it would be cheaper. So they wouldn't be demanding behind the scenes that the plant be built further away. And I object to the inclusion of a lobbying record somehow suggesting that my client violated the administrative code and the land development code.
And that, again, it's outside the scope of this proceeding, so.
Well, it was said, it was flashed on the screen, so, and I didn't have the right to object, but I object.
I'm stopping everybody to say, I don't want to treat anyone differently than everyone else, and so that we're not discussing that.
No, I appreciate that. And I have, and I won't bore you with it today, but I have included in the memo the fact that, and I agree with what the staff said and what Alexis said, the decision has to be made based on competent substantial evidence. That evidence was presented in the record below and was referenced again today. And Mr. Rodriguez did a superb job in going through the FAA stuff. I would not dare to tread on his authority and expertise. But what I would say is the circuit court does not have the ability to reweigh the evidence. As you know, under the administrative code, the hearing examiner makes the recommendation, and the hearing examiner weighs the evidence that comes before the hearing examiner and makes a recommendation to the board. The board doesn't sit in a de novo capacity, it sits in an appellate capacity. So when the board acted, regardless of what one commissioner may or may not have said, they did it based on the record and the recommendation. And if there was competent substantial evidence in the record, which I submit there was, the circuit court had an obligation to uphold the decision and not reweigh the evidence, and unfortunately not go into some of the site location issues and whether it should have been 2020. Those things have no bearing on the zoning issues. So I would submit that the recommendation was correct. Lee plan was met, 34-145 was met, and I would go a step further and say that the planning that the county did was required by state statute, and the county should not be faulted for upholding the law. Thank you.
That was the last card that I have. Is there anyone else that wished to speak today? Okay, thank you. Do we need to take a break before we come back for a rebuttal or closing comments? Okay, if applicant's ready then, please.
Alexis Crespo for the record. We have no further testimony to provide the hearing examiner, and we'll just reiterate that we submit the record is robust in terms of competent, substantial evidence to support the CFPD is entirely consistent with the Land Development Code and Lee Plan, in addition to the new information put on the record today about the FAA circulars.
Could you correct, there was one slide that was shown that showed that the site was within 10,000 feet of the airport. I don't recall where that was, but can you just correct or clarify that for the record? I'm not sure where that graphic came from.
Per the staff report and slides that staff presented, the site is right now 18,000 feet plus or minus from the current runway, and upon expansion of that runway will be still approximately 13,000 feet away.
So that was examined both prior to the application and prior to the hearing to ensure that it remains outside of the 10,000 radius.
Correct.
Thank you.
Thank you.
Does staff have any closing comments to put into the record?
I just have one point of clarification. Anthony Rodriguez again for the record. We did hear some public comment relative to the circling of aircraft when awaiting to land at the airport. And I wanted to note, and I want to highlight this particular section. This is Advisory Circular AC 150/4190B. This is an excerpt from page 2-11 of that document. It's attached as attachment E2 of the staff report. And it talks about the frequency in particular of bird strikes during either landing or takeoff activities of an aircraft. And what it notes is that the majority of these airstrikes happen at or below 500 feet above ground level. And I'm not an expert in aviation, but in terms of just my personal experience, having flown on airplanes and having to had circle an airport waiting to land, that activity does not happen at that elevation. And so I just wanted to make that a point of clarification, that this advisory circular acknowledges that there is a potential for bird strikes to occur as a result of incompatible uses being placed in proximity to an airport, but it highlights in particular where those happen with the greatest frequency. And I just wanted that to be clear in the record, that when that activity occurs, it may occur over the subject property, however, it occurs at a height well above of what the FAA acknowledges where the majority of those strikes occur. And so I just wanted that to be clear.
Okay.
Thank you.
Thank you everyone for coming today. I know there's a lot of frustration and I do feel it, I hear it, I receive it. I understand everyone is not satisfied with the process, but again, I am charged to follow the law, and that is what we have done today. So thank you, everyone, for your time and for your respect. I will issue a recommendation in this case to the board, and it will go to them for the final hearing. If you spoke today, you are welcome to attend that hearing, and if you completed a card, you will get a copy of the recommendation as well as the notice of when the hearing will occur. So thank you, everyone, for coming. Please stay well.